don't wait too long. Start thinking about the legal stuff early, and you won't regret it.
Hi, everybody. My name is Richard. Welcome to A Better Lifestyle. Today's topic is business law. So we're going to talk about everything we need to know on the legal side of business. And I have the pleasure to have Gordon Firemark. He was here a while ago, so I thought I'd bring him back again because being educated on business and everything related to business is pretty important, so we don't get in trouble. So, Gordon, tell everybody who you are, a brief resume of who you are, and we'll jump in right into the topic.
Sounds great. Hi, Richard. Thank you for having me. I'm Gordon Firemark. I am an entertainment, media, and business attorney. I live and practice near Los Angeles, California, and the entertainment industry is here. I do a lot of work with small businesses, folks that are starting, in the online entrepreneurship space, on online courses, anybody who's creating content, media, and podcasters and filmmakers. And I'm just here to help people do their thing and get their message out and make an impact on the world. So I make my impact by helping my clients make theirs.
Great. So my first question is, like you said, you help people starting their business.
Yeah.
What, as a business lawyer, what services do you offer to business people, whether they're self-employed, small business owner, or corporation, big corporation? What do you offer?
Well, I'll start off, I consider myself to be an advisor. I like to think I'm a trusted advisor, and I try to be a counselor to, I help clients sort of figure things out strategy wise and what their next steps are. And so that's the brain work part of what I do. I also help them, of course, with the setting up of corporations or limited liability companies or partnership agreements if they're forming a partnership. And anybody who's going into business together needs to really sort of think about the legal business structure of what they're doing in order to protect themselves against risk and liability, and to document the nature of the ownership relationship among the owners of the company if there's more than one, and possibly even how they're going to raise capital to get the business off the ground and those kinds of things. So corporations, limited liability companies, partnerships, those sorts of things. I also help with all of the transactional work related to bringing on the team. I'm not an employment lawyer, so I usually defer to an HR specialist for those kinds of things. But if you're working with independent contractors, if you're working with consultants or freelancers and those kinds of things, I help with those contracts, and also with all of the intellectual property creation, ownership, transactional stuff, registering and protecting your copyrights, watching out and licensing other people's copyrights for material you're incorporating into your show or product or those kinds of things. Trademarks, how to protect your brand. I don't do patents, but I have good people I refer that stuff to. And then, of course, when it comes time to, working with clients and customers, I can help out in that regard as well with all the deals and the contracts and the structures. And really, I hope to think I'm one of the earlier calls in any large transaction for sure, so that we can anticipate the problems and set things up so that it runs smoothly.
Okay. Do you touch the real estate industry? No.
I am not a real estate lawyer. I would definitely be hands off on that. I refer things out. A lot of times clients treat me as their sort of in-house general counsel or outside general counsel, much the way an in-house lawyer would, and they would bring in specialists to do the exceptional stuff. After all, you don't want your general doctor doing heart surgery and then switching over and doing brain surgery and then operating on your foot at the same, maybe they're qualified, but still, let's use the specialists for the things we need specialists for.
What do you think entrepreneurs, business people neglect when they're in business?
I think they neglect to think about the legal stuff until it's almost too late. Very often they never get anything down in writing between and amongst the co-owners or or the people that are putting the show together, the thing together, whatever the business is, until there's some kind of trouble brewing. And by that point, the pressure is on, and it's late, and that tends to make things more expensive and more fraught, and headache inducing kinds of things.
Okay. Can you give us maybe one or two examples of situations that with everything that you saw as a business lawyer, can you give us maybe one or two situations that could help some people that are in business, that mistakes
Sure.
to avoid and stuff like that?
Yeah, sure. I mean, I think if you're going into business with a partner or a colleague of some sort, they say good fences make good neighbors, and I'd say good contracts make good business associates as well. Here, an example of a situation where the client actually waited until trouble was brewing is this guy started a podcast network, and then he started a particular podcast focused on a particular very popular TV show at the time. And in the course of developing that podcast, he ended up bringing on guest co-hosts from time to time. And one of those guests sort of stood out as being really good, and he became more regular until the point was he was doing every episode. And then the founder of the show actually sort of started backing out a little bit and not being on every episode. And eventually the two of them, they had a little bit of a disagreement about how were they going to monetize the show. Were they going to use advertising or donations from patrons and do a premium content kind of a thing? And they were going back and forth about this over text. And then one day the founder just said, you know what, why am I arguing? It's your show. We'll do it your way. And the co-host, now the main host of the show, took that "it's your show" message to mean you own it, it's yours, go take it and do what you want with it. So he decided, well, I'm going to pull it off this network, and I'm going to do it as a solo show without the co-host and all those kinds of things. And he basically tried to take over ownership of the podcast, the business. And this had many listeners, and so it was capable of being monetized to a nice degree. They stood to make a lot of money a week from making this podcast, and all of a sudden it's going to go off the network. And so had he gotten his ducks in a row, my client, with the paperwork early on, what I refer to as a podcast prenup, some kind of an agreement between them that laid out the nature of the relationship, I don't think any of this would have happened. And frankly, I think he would have been more cautious about texting things like "it's your show." So yeah, I mean, just don't wait too long. Start thinking about the legal stuff early, and you won't regret it.
Do you have another one that comes to mind that could help?
Well, I mean, there are always situations when a business owner will, it depends on the business, of course, but in my industry is mostly media businesses. They'll be wanting to use a piece of something that they've found out on the internet, a photograph or a piece of music or a famous poem or something like that, and they'll without thinking about it, they'll just sort of drop it into a video or drop it into a podcast episode that they're recording or something, and without really realizing or acknowledging that, well, somebody else owns that thing. And so it's necessary to get licenses and permission, or you can suffer some pretty grave consequences. The dollar values of the damage awards can be significant, but the legal fees of fixing it after you've done it wrong often are much more consequential than it would cost to do things right at the beginning. Another example is with the trademark, the brand name for the business. By the time you realize that somebody else has something similar, that they're competing with you or confusing the marketplace, the damage is already done. And if you don't have your trademark registered and protected, you're going to be in a position of paddling upstream to get the other side to stop, and you get into arguments, even lawsuits about those kinds of things. So early and often, think about the legal.
Last time I had forgot to ask, so since you were talking about that trademarks and all that, the copyright, what is fair use of a music? Like, a lot of people are doing stuff online. What would you
Yeah.
say it's fair use of someone using someone else's song? Because I know like there's you could get free royalty music online. There's that.
Yeah.
But what's fair use? Because I know you have mentioned that on another podcast, so I want you to elaborate that
Sure.
for my audience. Who would if they use something, and what's the fair use, or how can
It's
they?
Yeah, this is probably the most common question that I encounter, or at least among the most common. Fair use is a defense under U.S. copyright law. It's specific to the United States copyright law because here in the U.S. we have a First Amendment of our Constitution, which provides special rules for free speech and freedom of the press. So fair use is a balancing that has been developed over the course of about a century of court cases that deals with this law that says you can't copy things that belong to other people, even if you're putting them in your speech or newspaper or media, whatever, along with a constitutional provision that says you have freedom of speech. And so that inherent conflict led to judges developing this thing called fair use. We're going to just say under certain circumstances, the use of copyrighted material is allowed, non-infringement, if it meets certain tests, if it weighs more in favor of freedom than protecting the creative rights of the owner, of the author of the material. And so we have to look at a very complicated 4-part test. For each alleged infringement, we have to look at these 4 factors. First factor, and none of them is a decision-making factor. It's the balance of all of them. So factor number 1 is the nature, or the purpose and character of the infringing use. Is it more educational or just more artistic or informational or entertainment, or is it more criticism and commentary of of the original work or something like that? So depending on which way we go, that weighs in favor of fair use or in favor of infringement. The second factor is the nature of the original work. Are they sort of in the same category, or are they substantially sort of different marketplaces, different things? And is there some transformation of the original into the new work? So, for example, if somebody was going to take advertisements from pages of a magazine and make a collage and hang it on a wall in an art gallery, that's a very transformative use, and it's sort of a commentary on the nature of advertising artwork or something like that. Very different from a website photographer, a website creator grabbing an image off the Google image search and posting it on their own website. That's pretty much the same. It's a photo being used as a photo to illustrate a website. So probably not going to be very transformative. The third factor is the amount and substantiality of the portion that was taken by the alleged infringer. This is where we get a lot of misconceptions. Excuse me. This is where we get a lot of misconceptions around, well, I only took 10 seconds, or I'm only using, the first 4 bars of the music, or it's only a small little bit of whatever, it's only a line from, or 2 lines from the book. That may or may not be substantial, and it's in relation to the original work as a whole, the amount and substantiality. So the example I like to use is, if you know Beethoven's Fifth Symphony, and assuming that Beethoven was living today, or the symphony was still covered by copyright protection, it would only take us 4 notes, actually 1.5 bars of the music to infringe the bum, 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 bum. That's a very deep hook. So it's not just how much quantitatively, but also qualitatively has been taken. And the more substantial that is viewed, the less likely we'll find fair use. And then the fourth factor is another misconception-inducing one. That is that You commonly hear people say, well, I'm not making any money from it, so it's okay. That's not the way it works. It doesn't matter whether you're making any money from it. It's whether the owner of the copyright is losing some money or losing an opportunity, or the value of the original is being reduced as a result of this infringement. So it's the market impact or the impact on the market or the value of the original, not the defendant's profit side of the equation. That's really what's important. So we take those four factors and we balance them out, and a judge or a jury makes a decision. I think it's fair use, or I think it's infringement, and that's how we do it. And then we move on to the next infringement. If you've got a movie that has 5 or 10 clips from other things in it, we're doing that same analysis 10 times over. So it's very time consuming and expensive and unreliable. There really are no rules of thumb. So I always caution, don't rely on fair use, except in very narrow circumstances. If you're doing news, if you're doing a documentary film, you're more likely to have fair use. But by and large, most of the time, people think they're doing fair use. They're actually not.
Let's say you, it just crossed my mind as you were saying that, you were talking about that. Let's say, because I was in the music industry before, I was doing some music before. Let's say someone, it always crossed my mind, if someone is singing or rapping and they're mentioning someone's name in their song, is that okay? Could they get in trouble, or what's?
Generally, just mentioning, again, in a work of art like this, generally mentioning somebody's name is not going to amount to an infringement of any of their private rights. Now, names and likenesses come under a different area. It's not copyright, it's not trademark. It comes under an area of law known as the right of publicity, or sometimes it's the right of privacy, the misappropriation of a unique characteristic of a person, the name, likeness, sometimes the sound of their voice. But that really generally only applies when the use in question is a commercial use. And by commercial, I mean proposing a transaction like in an advertisement. So merely mentioning or calling out the name of a particular celebrity or something like that when writing a song or something like that, that is not generally going to be a problem. There have been a few cases that sort of address this more in a trademark context, where one of the famous cases was a movie was released, an Italian film that was titled Fred and Ginger. And Ginger Rogers, from the Fred Astaire and Ginger Rogers fame, felt that was infringing on her brand, and she sued and ultimately ended up losing the case because it was merely an expressive work. It wasn't an ad.
Okay. So on the business side, if someone is buying or selling a business, a buy-sell agreement, how does that usually work?
Well, there's lots of different ways that it can work. Sometimes a buy-sell agreement is typically between co-owners. If you're forming a company together, you may decide, well, if one of us decides to quit, then the other one can buy them out. Or maybe we're just not getting along, and so one wants to buy the other party out. There can be a mechanism built into the contract, into the LLC or corporation or between them, that just says, here's how we're going to do it. And usually what it involves is some figuring out a way to put a valuation on the business. What's the company worth today? And sometimes that means both sides hire their own appraisers and then we take the average, or sometimes both sides make a list of appraisers and they pick one who's on both lists, and that person comes up with a valuation. There's lots of different approaches to it. And I'd say that valuation is the most significant, hotly debated issue in a buy-sell. One thing I've seen that I think is kind of clever, especially for smaller businesses and ventures where there's, maybe not a tremendous amount of value, is one party just says to the other, I think the company is worth this, and I want us to go our separate ways. So I will offer to buy it from you for this price, or sell it to you for that same price. I call it a Russian roulette provision, where you don't know whether you're the buyer or seller. The other party gets to decide, are they buying or selling? But that's what triggers the dissolution. We're gonna go our separate ways. Are you buying or are you selling? And here's the value. And it forces the person who's making that offer to pick a value that's fair and reasonable, or at least theoretically forces them. and so that's the buy-sell agreement. Now, if someone new was just coming into the equation and wants to buy the company, really the same issue. What's the company worth? How do we put value on that? And sometimes we refer to the book value on, the accounting numbers for the company. Sometimes we have an outside expert come in and value the company based on an assessment of all the assets and the marketplace and all those kinds of things, and get the economists involved. But then ultimately it just comes down to, what are the purchase terms? Who's going to pay who, when, and how much, and how often, until the amount of the purchase price is paid off? And what are we buying? Just the assets, or the whole company? You can buy the shares of the company, and then you're buying the entire thing, warts and all the assets, all the liabilities, and all the ongoing business, and that kind of stuff. So lots of different variables in purchasing a business. Definitely want to get a lawyer involved.
Yeah. Speaking of the value of the business, if the business owner played with the numbers, how can someone find out? Or
well, I think it's up to the due diligence of the buyer. Let the buyer beware, as they say. If look at what's happening right now with Elon Musk, saying he was going to buy Twitter, and then he went and started to do some due diligence and decided that for whatever reason, maybe the company isn't worth what they said it was worth. And that's really what that dispute comes down to. So you got to do an investigation. You hire your accountant or an economist to come in and look at the books and look at, why are they taking so much money in advertising when all they're doing is running a Facebook ad once a week? Or why is this company showing, the profits of so much? Why is the water bill for this laundromat so low? We know that if it's a successful laundromat, it's using a lot of water. So you can sort of measure things according to outside references. And again, it sort of depends on the business, and you want to use someone familiar with the business, the kind of business you're getting into, to assess that and just come at things with a bit of a skeptical eye.
Is a shareholder agreement in the same line as a buy-sell agreement? Or
well, sometimes a shareholder agreement includes a buy-sell provision. The real purpose of a shareholder agreement is to make sure that the company is going to be managed a certain way for at least the foreseeable future. So usually it's used in smaller companies where the shareholders are friends or family, or pretty well acquainted with each other. And the concern is that they're not going to vote the officers out of the company, and the founders of the company aren't going to be voted out by at the end of the first year or something like that. So oftentimes shareholders agreements will say, we've agreed that we're going to vote this way. Or oftentimes it is, if you decide to sell your shares, you'll sell them to the other shareholders first. Those kinds of provisions.
Okay. How do you deal with a breach of a contract?
Hire a lawyer. No, I think that, honestly, that's too glib of an answer. I would say, if you are in a situation where you have a contract and somebody either owes you money or owes you performance of an obligation, start by not assuming the worst of the person or the company. Assume that there's some reasonable explanation and try to work it out. Obviously, if it gets to the point that they're not gonna make things right, then you don't have a lot of choice. Sometimes there's a mechanism in the contract for dealing with those kinds of things. Sometimes there's a way, if it's a recurring orders from this company, you may have to withhold something else, withhold payment on the next delivery or something like that. You got to check the contracts and read and understand what your remedies are. But ultimately, it probably does come down to filing either a lawsuit or an arbitration claim or something against the breaching party. And then you're going for your remedies, either make me whole of what I was expecting, or put me back where I was beforehand. And there's a few other kinds of remedies available as well. But
can you explain what is litigation?
Litigation is the process of engaging in a lawsuit, hiring lawyers and taking things to court, fighting it out.
Okay. So about the entertainment, because you do entertainment, you were saying like you help for people who are doing business online too.
Yeah.
What have you seen like people are doing? Because there's a lot of business that could be done online, whether it's e-commerce or is the e-commerce is coming to my mind, but I know there's other business. But how does the whole like business law affect?
Well, I'll say, in like the entertainment industry as well, you're doing it's business law against a backdrop or in a context of a somewhat unusual kind of a business. In entertainment, we have lots of egos and lots of creativity involved. In online digital business, we have the lack of a physical location for the business in many instances. And so those they add wrinkles to the landscape of things. But ultimately, these issues come down to, what does the contract say? What is the agreement? What's the arrangement between the parties? Or what law governs this? There may be privacy law that governs something where you're doing business through a website. And if the website is gathering information about the people who visit it, or credit card information when you pay, after all, it's business, right? So you're getting payments. Different states, different places in the world will have different rules about how those things happen. And so you want to be mindful of how you're choosing. Obviously, most companies want to have their, if they're going to get sued, if they're going to have disputes, it's going to happen here at home where I am, so we don't have to incur the extra costs of travel and being taken to court someplace else. So you'll often see that provision mentioned in the terms of use of the website or something like that. I'd say when you're doing business online, you've got to have a privacy policy that complies with not just your local law, but also the law that relates to wherever your customers are. If that's California, then you've got to comply with the California privacy law, which requires certain things in your privacy policy. If you have customers in the European Union, you've got to comply with the GDPR, the General Data Protection Regulation over there. You may remember a couple of years ago, there was this flurry of activity where companies were all getting new consent from everybody that's on their mailing lists and things like that. That was all part of the GDPR going into effect. And so there's a fair bit to do with privacy policies. It's also a really good idea, and privacy policies are required by law. Every website should have a privacy policy that clearly outlines what information we're gathering about you, what we do with it, who we share it with, how long we keep it, where we keep it, and how we protect it, and how you can opt out or have it removed, and those kinds of things. Beyond the privacy policy, we also have a terms of use or terms of service agreement. This is the contract between the owner of the website and the visitor. Whether the visitor buys anything or not, it's still, you're forming a contract. I'm providing you with this information in exchange for your agreement that if there's a problem, you'll let me know this way. And if there's an infringement of copyrights, you'll follow this procedure. And if you need to complain or sue, you'll do it here in my home state, those kinds of things. So privacy policies, terms of use or terms of service. And then there's the disclaimers of, if you're offering advice or things that people might rely on, and it could be backfiring on them if they don't do it right. You want to make sure you're protecting yourself with disclaimers. And then, of course, if you have actual customers and clients coming to you through a website or something online, you need to have that contract clearly articulated. It's usually on the sales page with the customer.
Thanks, Gordon, for being here. It's always a pleasure to have you.
Likewise. Thanks for having me, Richard.
On the show. Where can people find you if they want to find more about I know you do you don't have your own podcast, but I know you do your monthly podcast with another co-host. I forgot what her name is.
Yeah, my podcast is called Entertainment Law Update. My co-host is Tamara Bennett. She's a Texas-based music lawyer, and we've been doing this podcast. It's my podcast, but it's her as my co-host. We've been doing it together now for a little over 13 years and having a great time, and no end in sight. The best way to find me is search for my name, Gordon Firemark. That's Firemark. You will find me and only me, because it's unfortunately a distinctive name. But firemark.com is my law practice website and blog, and gordonfiremark.com is where I have, various of my other offerings for online businesses and podcasters and folks like that, where you can find out more about what I have to say.
Great. Any last words you would like to say concerning business law, entertainment law? Anybody who's someone who wants to get into business or entertainment, like any advice for concerning the law in general?
Well, maybe it's a little more philosophical, but I would say, getting these legal things that we've talked about today done early is a sign of professionalism, and it is an empowering thing, because until you officially decide, I'm going to do this in a professional way, you're always going to be holding back a little bit. You're always going to be maybe a little timid or a little cautious, because your unconscious mind knows, hey, I don't have all my ducks in a row, my T's crossed and my I's dotted, and so maybe I'm not going to take that little risk here, because who knows what could happen? I haven't thought it through, or I'm exposed somehow. When you get those things taken care of, the entity structure, the relationship with your team and your partners, and the intellectual property protection in place, and all the contracts in place, you've done things right. And so you're going to be a little more tolerant of risk, and risk is where the big wins come for businesses. Until you start taking risks, you're just going to stay where you are. And so get legit, go pro, take some risks, and prosper. That's my message.
Great. Thank you, Gordon, for being here. I hope everybody found some value in that episode. So I know I learned a lot. So I always like to know more about how to do things proper, not to get in trouble, especially when it comes to business or in my professional life. So thank you, Gordon, for being here and educating us. On that note, everybody, thank you for listening and watching this podcast. Welcome to A Better Lifestyle. My guest was Gordon Firemark, and my name is Richard, and we'll see you on the next episode, everybody. Bye.